On January 20th, 2026, the Supreme Court delivered a unanimous decision that will be remembered as a turning point in American legal history. In a rare moment of complete agreement, all 9 justices stood together to issue a verdict that will echo for generations. This landmark ruling will fundamentally reshape the boundaries of privacy and government surveillance in America, affecting how citizens interact with technology and how the government collects and uses personal data. The court struck down a controversial federal program that had quietly created a de facto national registry of firearms. In their opinion, the justices made it clear, advances in technology cannot be used as an excuse to erode the constitutional rights that protect every American. The ruling emphasized that the right to privacy and the right to bear arms are not relics of the past, but living principles that must be defended in the digital era. This decision is about far more than just gun ownership. It's a sweeping statement about the limits of state authority in the age of big data. The court's message is clear. The government cannot use new technology to sidestep the Constitution, and the rights of individuals must remain at the forefront, even as society changes. The decision has sent shockwaves through Congress, Silicon Valley, and law enforcement agencies nationwide. Lawmakers are now scrambling to respond. Tech companies are re-examining their data practices, and police departments are reassessing how they gather and use information. The nation is being forced to confront a fundamental question. How do we balance the need for security with the promise of liberty? The journey to this historic verdict began quietly, with a little-known data-gathering initiative that soon ignited a fierce constitutional debate. As the program expanded, concerns grew about its impact on civil liberties, drawing the attention of privacy advocates, legal scholars, and eventually, the highest court in the land. The court's rare and powerful consensus sends a resounding message. Some rights are simply too fundamental to compromise. This decision sets a bold new precedent for freedom in the digital world, reminding us all that the Constitution remains a living document, one that must adapt to new challenges, but never at the expense of our most cherished liberties. The story of United States versus Miller II begins in the heart of Washington, D.C., where the federal government unveiled a sweeping new initiative known as the AFAR program. This program, short for Advanced Firearms Acquisition Registry, was introduced with the stated goal of bringing the nation's gun sales records into the digital age, promising to streamline law enforcement investigations and enhance public safety. Under the new rules, every licensed gun dealer across the country was required to digitize decades of handwritten sales records and upload them to a centralized federal database. This marked a dramatic shift from the traditional paper-based system that had been in place for generations, and it meant that millions of transactions, once scattered and difficult to access, would now be instantly searchable by federal authorities. Government officials argued that this modernization would help investigators quickly trace firearms used in crimes, close loopholes exploited by traffickers, and ultimately save lives. They held press conferences touting the program's benefits, emphasizing the need for updated tools in a digital world. But not everyone was convinced. Critics, including privacy advocates and gun rights supporters, saw the AFAR program as a thinly veiled attempt to create a national gun registry. They warned that collecting and storing detailed personal information on millions of law-abiding Americans posed grave risks to privacy and civil liberties and could be abused by future administrations. Among the most vocal opponents was Sarah Miller, a Texas gun shop owner who joined forces with prominent gun rights organizations. Together, they filed a lawsuit arguing that the AFAR program violated the Fourth Amendment's protection against unreasonable searches and seizures by forcing innocent citizens' data into government hands without suspicion or warrant. Their legal team contended that aggregating the private information of lawful gun owners into a massive searchable database amounted to an unconstitutional dragnet. They argued that such sweeping surveillance would have a chilling effect, discouraging people from exercising their rights out of fear of government monitoring. The case quickly became a rallying point for Second Amendment advocates, who saw it as a direct threat to the right to keep and bear arms. Across the country, gun owners voiced concerns that the AFAR program could be used to track, target, or even confiscate firearms in the future. In 2025, the Supreme Court agreed to hear the case. Uyasin Anatspuri recognizing its profound implications for both privacy and gun rights in the digital era. The nation watched as the stage was set for a historic legal showdown, one that would determine just how far the government can go in tracking constitutionally protected activities. At the heart of United States versus Miller II lies a fundamental question: where must the digital frontier of government surveillance end, and how do we balance security with the freedoms enshrined in the Constitution? At the heart of Miller II was the AFAR program's powerful technology, efficient, centralized, and capable of analyzing gun owner data nationwide. The government called it a modern filing cabinet. Plaintiffs called it digital profiling, treating every gun owner as a potential suspect. The case forced the court to confront how analog-era constitutional protections apply to mass digital data collection. Plaintiffs argued that the scale and searchability of AFAR transformed routine records into a tool of mass surveillance. The Supreme Court had to decide, does the Constitution protect us from this kind of digital dragnet? On January 20, 2026, the Supreme Court ruled 9-0 for Sarah Miller, striking down the AFAR program as an unconstitutional search. The court held that mandatory, suspicionless collection of firearm transaction data violated the Fourth Amendment. Chief Justice Roberts wrote that digital modernization cannot come at the cost of constitutional safeguards. The government must dismantle the database and return to dealer-held records, accessible only with a specific warrant. The ruling is a major setback for federal law enforcement's data-driven strategies and forces a complete rethinking of investigative tools. The court's unity sends a clear message: constitutional rights cannot be overridden by technological convenience. This decision sets a powerful precedent for privacy in the digital age. Chief Justice John Roberts delivered the court's opinion with a firm grounding in the history and principles of the Fourth Amendment. He emphasized that the founders designed this amendment to protect citizens from broad, suspicionless searches by the government. Roberts made it clear that mass data collection, especially when it sweeps up information about millions of people without any individualized suspicion, stands in direct opposition to these constitutional values. He referenced historical abuses that inspired the Fourth Amendment, warning that modern technology should not erode the protections our Constitution guarantees. Justice Sonia Sotomayor, in her concurring opinion, sounded a broader alarm. She cautioned that while today's case focused on a gun database, the principles at stake could easily extend to other areas of life. She warned that if unchecked, similar surveillance tools could be used to track protesters, monitor what people read, or even chill free expression. Sotomayor's words highlighted the far-reaching implications of the ruling, reminding us that the decision was not just about gun rights, but about the fundamental freedoms of all Americans. Justice Neil Gorsuch, writing separately, drew a powerful connection between different constitutional rights. He argued that no one should be forced to give up one right in order to exercise another. Specifically, he linked the Second Amendment's right to bear arms with the Fourth Amendment's right to privacy, insisting that Americans should not have to surrender their privacy to exercise their lawful rights. The court's unanimous consensus sent a strong message. The AFAR program's sweeping design was fundamentally incompatible with the Constitution's protections. The justices agreed that the program's reach was simply too broad and invasive to be justified under the law. Even those justices who are typically more deferential to government claims of public safety found that the AFAR program crossed a constitutional line. Their agreement showed that the need for security cannot override the basic rights of privacy and liberty. The ruling was not about making minor adjustments or tweaks to the system. Instead, it drew a clear and unmistakable line against the dangers of mass surveillance, reaffirming the court's commitment to protecting individual rights in the digital age. The absence of any dissenting opinions underscored just how important the principles of privacy and liberty remain in American law. The justices stood united in defense of these enduring values. This landmark precedent will shape the future of digital privacy law for years to come, guiding courts and lawmakers as they confront new challenges in an increasingly connected world. In the wake of the decision, federal agencies are scrambling to halt AFAR and delete the vast trove of gun owner data. Dealers return to the old system, relieved to stop acting as data entry clerks for a national registry. Sarah Miller calls it a victory for every American who values privacy and constitutional rights. Law enforcement, now deprived of rapid digital tracing, faces new challenges in solving gun crimes. Policymakers must find ways to support investigations without crossing constitutional lines. Politically, the ruling has sparked calls for oversight and shifted the debate from gun types to government tracking. The intersection of privacy, technology, and the Second Amendment is now central to American politics. The decision ensures this debate will shape policy for years to come. The Miller 2 decision is reshaping the national conversation on gun control and surveillance. The administration faces criticism for overreach, while opponents hail the ruling as a victory for liberty. Both parties must now address digital privacy, not just gun policy. Tech firms lose lucrative contracts, but new markets for privacy-preserving solutions may emerge. The firearms industry could see a boost as fears of a registry fade. The ruling unites unlikely allies, reinforcing the idea that digital privacy transcends politics. Law enforcement must adapt, investing in new strategies that respect constitutional boundaries. The debate over freedom and security is far from over. It's just entered a new phase. Legal scholars call Miller II one of the most significant Fourth Amendment rulings of the century. Professor Oren Kerr says the court has drawn a clear line: mass data collection is a search, and this program crossed it. Jonathan Turley notes the 9-0 decision sends a powerful, non-partisan message that transcends politics. The ruling is seen as a bulwark against future attempts at national registries. ACLU's David Cole says the decision protects not just gun owners, but all Americans from government overreach. Some public safety experts warn of challenges for law enforcement, but agree the constitutional reasoning is sound. The task now is to craft investigative tools that respect privacy and the Constitution. The ruling is a win for the fundamental right to be left alone. The Supreme Court's unanimous ruling is the start of a new national dialogue on freedom and security in the digital age. Congress and the White House must now find ways to support law enforcement without violating constitutional boundaries. The era of mass data collection is over. The future demands creative, rights-respecting solutions. This case is a reminder that constitutional rights require vigilance and defense by ordinary citizens. The story of Sarah Miller proves individuals can stand up to government overreach and win. The legacy of Miller the Soudensten ein will be shaped by new laws, technologies, and public engagement. The Constitution remains a living document, protecting Americans against new threats. The conversation about privacy and liberty is just beginning, and its outcome depends on all of us.